Hello everyone, welcome to Court with Krissy. Here are 4 short court clips you probably didn't catch. And I'm kicking it off with Judge Shackelford. She is a doppelganger defendant in her courtroom. I hope you like it. Court with Krissy is now in session.
There you are, I see you.
Okay.
Okay, we're on record on 250-330-OM, 250-337-OM, and 250-339-OM, the People versus Ricardo Calhoun.
Your Honor, Elias Muad P 41632 representing Mr. Calhoun.
All right, Mr. Calhoun, can you tell me your first and last name?
Ricardo Calhoun. Hey, Your Honor, you mind if I put my glasses on? I'm kind of outside and I really need them to see, but they dark. Is that okay for you? Or just leave them off? I'll leave them off.
Okay. All right. So we have here today, I have a plea agreement in front of me, where if Mr. Calhoun pled guilty on the 0330 case, the 2 other cases would be dismissed. And there's also notation on here that there's restitution in the amount of $2,056 to J.C. Penney.
That is correct, Judge. Everything you just said is correct.
Okay, so first things first, I don't see that Mr. Calhoun has been arraigned.
Okay.
So as to arraignment.
Stand mute, Judge. Waive the reading and stand mute, Judge.
All right, I'll enter a not guilty plea on his behalf on these 3 files. Okay, and then Mr. Calhoun, did you go over your constitutional rights with your attorney?
Yes, ma'am. Yes, Your Honor.
All right, I'm gonna go over some of them specifically with you before we take this plea. Sir, you've been brought to court on misdemeanor charges. Each of these 3 cases is a misdemeanor, punishable by up to 90 days in jail, a fine of up to $500 or 3 times the value of the property. Do you understand that?
Yes, Your Honor.
All right, your attorney has waived the formal reading and not guilty plea has been entered on your behalf with terms to arraignment. You have the right to a jury trial and you have the right to assistance of an attorney. Okay, if you couldn't afford an attorney, one will be appointed at public expense. If there was a minimum jail sentence, which there is not on your offense, or the court determines it might sentence you to jail. You may have to repay the expense of the court-appointed attorney if you did have a court-appointed attorney, if the court determines that you were able to pay at that time. Do you understand that?
Yes, Your Honor.
All right, you have a right to a trial. And at the trial, you would have the following rights: to call witnesses to speak for you at trial. And you could get an order signed by the court to require witnesses to come to court. You have a right to see and hear and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. You also have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand all of that, sir?
Yes, Your Honor.
And you understand if you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind and you will give up the rights I've just read to you.
Yes, Your Honor.
Do you understand that if you are currently on probation or parole and you enter a plea of guilty, it could result in a violation of your probation or parole?
Yes.
Okay. And you understand that fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment, except when the court allows otherwise for good cause shown. If you're not able to pay due to financial hardship, you could contact the court immediately to request a payment alternative. Do you understand all of that?
Yes, ma'am.
Okay. Sir, you also understand that if you are not a citizen of the United States and you enter a plea of guilty, it could be a violation of your conditions.
Yes.
Yes. Strike that. You are not a citizen and you enter a plea of guilty, it could have immigration consequences up to deportation. Do you understand?
Yes, Your Honor.
Okay.
Yes.
Knowing all of that, how do you plead the larceny?
Plead guilty, Your Honor.
Has anyone forced you to get you to plea?
No.
Has anyone promised you anything other than the plea agreement to get you to plea?
No, Your Honor.
Are you pleading guilty of your own free will?
Yes.
Sir, were you in the city of Taylor on December 18th of 2024?
Yes.
And were you specifically, did you go into a J.C. Penney's?
Yes. Yes, Your Honor.
All right. And did you take something from J.C. Penney's that would make you guilty of larceny, sir?
Yes, Your Honor.
What did you take?
I don't know exactly what it was. I'm thinking maybe some house shoes.
Okay. And did you pass the points of sales? Did you pass the cash registers with that item?
Yes, yes, Your Honor.
And did you do it with the
Yeah.
intent to deprive J.C. Penney of their property?
Yes, Your Honor.
Mr. Mawad, are you satisfied with the factual basis?
Yes, Judge, very satisfied. Thank you.
Okay, I'm going to accept the plea as knowing and voluntarily given. Mr. Calhoun, you're a thief.
Yes.
You should have been charged with a felony. You have bad character. I know that just from looking at the amount of product that you stole from J.C. Penney over the course of multiple instances, and the fact that your criminal history dates, you've been stealing since I was 3 years old. You've been going into stores and buildings and other places and stealing since I was 3. And I'm no spring chicken. You're a thief. Their restitution has already been stipulated to. Is that correct, counsel?
It has, Judge.
All right, so $2,056 of restitution to J.C. Penney. Your client, sir, you're being referred for a pre-sentence interview. So you'll meet with the probation department and they will review all the facts in this and interview you, and then they'll make a recommendation to the court as to the appropriate sentence on this matter. So the other 2 files are being dismissed per the plea agreement.
Mr. Calhoun, you're going to be, judges, did they call him for the interview or does he call? How are you working it these days?
They'll send a notice out.
Okay.
And if he does not receive that notice within the next 2 weeks, he's to call the court.
Okay.
All right, so we're going to set some bond conditions, even though I need to know he's going to do some things while he's awaiting sentencing. He has a personal bond. He's already been out. So he has a $1,000 PR bond. Sir, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. Mr. Calhoun, if you can stop yourself from stealing while this case is pending, I'd appreciate that. You're to immediately notify the court of change of address or phone number. You're not to go into J.C. Penney, any J.C. Penney. I recommend you not go into any stores. You cannot shop at all without another adult present that isn't a thief.
Yeah, yes, ma'am.
You should be ashamed of yourself. You can't consume alcohol or illegal drugs. You could be tested on demand. And we will see you back on your sentencing date. If you don't receive notice within the next week or 2 of that pre-sentence investigative report, you're to contact court. Okay?
Okay.
And Mr.
You don't
Calhoun,
have to be ashamed of yourself, sir. You could just quit stealing. What else
got
is there?
you got it, Mr. Calhoun? You understand? She's trying
Yeah.
to, she's mad, but she's helped. She's trying to give you some good advice like me, okay? All right.
Okay.
All right.
Okay.
We're all set.
Thank you, Judge. Thank you, Mr. Calhoun.
Thank you.
All right, we'll call the matter of Zachary Bain, file 24-42697-SD, set for a status conference today. All right, see Mr. Bain.
Good morning, Your Honor. William Mays on behalf of Mr. Bain.
I hate to tell you this, but it's afternoon already.
Oh, there you go.
Still on the morning docket, but we're in the afternoon. So
There you go.
good to see you again, sir.
Good to see you.
There is a jury trial, I believe, set for April the 9th and the 10th. Is that going to go?
Yes.
All
I mean,
right.
unless the prosecutor's got an offer that's better than their last offer, we're ready for trial.
All right. Mr. Fortier, I assume nothing has changed from your perspective?
No, Your Honor. Ms. Brooker notes that she had filed the
Yep.
jury
All right.
instructions and should be all set.
Now, Ms.
I
Brooker,
have- Go ahead, sir.
thank you, Judge. So Ms. Brooker had indicated to me, I asked her, because I was doing some trial prep, and I realized that I never did get a copy of the video. I've seen the video in court, but only portions of it over Zoom. And I asked her, you know, did you ever provide me with a copy of that video? And she said, no, you got to pay $12 to get it. And I said, well, I take the position that unless there's an order for costs, you have to provide me with copies of whatever it is that you intend to introduce at trial. And if you're telling me you intend to introduce it, which she was saying she was, then she's under an obligation to provide a copy of that video to me. Otherwise, I would be moving to exclude it at the time of trial because they hadn't disclosed it prior to trial. She said that we would deal with that this morning.
Are we really fighting about $12?
It's really, it's the logistics of it. By the time that it even gets over there to them, and then they get it down to me, I don't get it. And so I'm just saying, I had suggested they send it by Carpel, which is a discovery service, an e-discovery service that they provide discovery through. So I've got a lot of paper documents, but they indicated that they don't know how to send a video. I get videos through Carpel all the time. So I guess what we're really fighting about is that they can either send it to me or they risk not being able to introduce it because they didn't disclose it prior to trial. Because their intention right now, I believe, is that I'll pick it up like on the fly on the day of jury trial, which will be insufficient.
And you're also risking proceeding to trial with a decision by the judge that said you knew about it and decided not to make a point, and you're going to go ahead anyway. So
Correct.
Either way, I have a jury trial set on the 9th, and you guys are fighting about discovery, which should have been done a long time ago.
Mm-hmm. I'm not asking for an adjournment. I'm ready to go forward.
Because you want an appellate issue.
Well, I've got a lot of issues already, but this is just a side issue that if they take that position, then, you know, it is what it is.
So, Judge, the only thing I will point out is that Michigan Court Rule 6.201A does note, obviously, the prosecution's obligation to disclose discovery materials, but it also indicates that a party may request a hearing regarding any question of costs of reproduction, including the cost of providing copies of electronically recorded statements, which naturally, in this case, the video would be an electronically recorded statement. Our office does not utilize Carpel for video services. Everything that we get comes from the agencies itself. And I think that might be where some of the disconnect comes in, because I know when I was in Clare County, we did utilize Carpel to send video discovery. However, the office here, we don't have that function through Carpel. So everything that we get comes in and it gets stored on an external server, and then it gets copied to whatever modem of media, whether it be a disk or a flash drive or something, and then it gets sent to the attorney that way. So I don't know. I don't know the extent of what Miss Brooker and Mr. Mays' communication was. I kind of got looped into an email at the end of it. Just kind of knowing our office's policy, reasonable costs for paying for the shipping to get it to the attorneys, and then also for the flash drive that gets provided, which that's not something that we ask to be returned. It's theirs. They keep it. I think $12 is entirely reasonable.
Well, I would point out, Your Honor, in response, that a flash drive costs about 50 cents. So that's not appropriate. But the cost provisions don't pertain to electronically recorded media regarding statements made by the defendant, which fall under 6.201B. The cost provisions are under 6.201A, apply to both parties. So the prosecution would have to pay my costs if I sent them a bill, and I would have to pay their costs if they sent me a bill for materials that fall under 6.201A, and that's only after a motion is filed. They have not filed a motion requesting costs or indicating that somehow this is something that needs to be borne by the other party or somehow shared by the other party. The fact that they're only trying to charge $12 indicates that the 6.201A provisions that talk about if the costs are excessive or something along those lines, then it may need to be addressed by the court. But, this is routine discovery that they're required to produce under 6.610E. I understand that it's not convenient, but, this was discussed when the Michigan Supreme Court adopted 6.610E in reference to the cost to the prosecution. Many prosecutors filed objections indicating that they would not have the ability to provide access to this discovery because of the costs. And the Michigan Supreme Court said that's not really an issue. You have to give this discovery. And the fact that this is something that they want to introduce as an exhibit, when they indicate if it were not something that they were going to introduce as an exhibit, that'd be a different story perhaps. But this is something that they intend to introduce at trial. So at that point, it's their burden to produce it before trial.
Your Honor, for the record, Mike Rolla from the Otsego County Prosecuting Attorney. With the court's permission, I would ask to give input in this matter.
Go ahead.
Thank you, Your Honor. This is a situation where the defendant has retained counsel. It is not court-appointed counsel. As it is retained counsel, our office is under no obligation to provide that without being paid for it. Further, even were this requested, even under a Freedom of Information Act situation, we're also entitled to charge the individuals for the cost per page. Counsel knows that, counsel's aware of that, and in this particular case, although I have not personally looked at the documents since this was just brought to my attention, I would be willing to bet that in our records it indicates that notification to counsel was sent to him indicating what the amount was and that it was going to be used, and that if he wanted copies of them, he would have to provide our office with payment for it. I would also further note that in this particular case, it's a $12 fee, which, by the way, is significantly lower than if our office were getting documents from prosecutors' offices farther downstate where they charge 2 and 3 times that amount.
Judge, in a brief response, that's not true. We're not asking for it under FOIA. FOIA clearly provides for cost provisions that's laid out in the statute. So whether a prosecutor's office has a policy or not, frankly, if the policy conflicts with the court rule commands. So whether or not they indicate this is what we want for the discovery, that does not entitle them to it. There is no cost provision that just automatically allows them to charge a fee for discovery.
All right, counsel, we're not going to do this today off the cuff. You guys are going to argue about this like this now. You're going to file briefs and you're going to give me something to base it on. We're calling off the jury trial because I'm not going to have a jury trial without the defense having a piece of evidence as important as a video. So we're going to set this for a motion hearing on April the 9th. You're both going to have briefs in on this issue prior to April the 9th. I'll make a decision on April the 9th. But we're not having a jury trial because I'm not going to listen to both of you guys argue about silly stuff like this when neither one of you is taking the time to put it before me on a proper basis. So briefs are in, should have 7 days in advance of April the 9th, so I have an adequate opportunity to review it. That would be April the 2nd. That gives you, I'll give you till Friday the 4th. So that gives you a full week, more than a week from now to get them in. So do your briefs, get them into me. We'll hear it on April the 9th. The jury trial for April the 9th and the 10th will be off, and we'll discuss it, what we do at that time. Thank you very much.
Thank you,
Very
Judge.
good. Thank you, Your Honor.
Thank you, Your Honor.
McCusin, people against McCusin. Jonathan Ryan McCusin, 23B 144450. Your name, sir?
Yes, Jonathan Ryan McCusin.
Counsel.
Thank you. House Counsel Attorney Mike Baldwin for Mr. Makusa. Judge, today's the date and time set for a free trial. I've had an opportunity to speak with the prosecutor. Mr. Makusa is going to plead guilty as charged to possession of paraphernalia.
Is that right?
Yes, Your Honor.
If you plead guilty to that charge, the possible penalties under local ordinance are up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
I do, Your Honor.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. If you plead guilty, you're giving up all those rights, and there will not be a hearing or a trial. You'll be giving up your constitutional right to a jury trial, waiving the requirement that they prove you guilty beyond a reasonable doubt. We won't have a trial of any kind. Do you understand that?
I understand, Your Honor.
To the charge possession of drug paraphernalia, how do you plead?
Guilty.
On November 26th of 23, were you in Brownstown at 19342 Allen Road in Brownstown at 10:54 p.m.?
Yes.
Is that a business or what was that?
A car wash.
It was not in service, Judge.
Okay, what did you have on you? What kind of drug paraphernalia?
It was a bong, and it was there was meth in it. It was not found in my possession, but I let the officers know that it was in the vehicle. At the car wash, I was disposing.
Slow down.
I was throwing stuff away.
Slow down. Wait. Stop. What drug paraphernalia did you have? You said a bong?
Yeah.
And what was the bong used for?
For meth.
Okay, and had you used it for that purpose before?
No.
Somebody else did, Judge, and it was under the driver's seat, and he was in the driver's seat.
Is that right, sir? Were you in the driver's seat?
I was driving. It was found in the passenger's front driver seat.
Did you know that was there?
No.
You didn't know it was there?
Your Honor, maybe we can do a no contest plea, and the police report facts are, they're detailed.
I want you to be honest with me now. If
They took the other person to jail.
Hang on. I don't care about the other person right now. I want you to just look me in the eye and listen to my question and give me an honest answer. Did you know that there was a bong in the car underneath the passenger seat that was used for the purpose of consuming methamphetamines? Yes or no?
Yes.
Why'd you just tell me no? Why you telling me stories here? I'm not in the mood for stories right now.
They never took me to jail.
I don't care if they took you to jail. I don't care if they didn't take you to jail. I don't care if they took you to McDonald's and bought you a hamburger. I just want to know, did you know that? Yes or no?
Yes.
Are you on probation or parole right now?
I'm on probation for the city of Wyandotte.
You understand by pleading guilty that if you were on probation, what's this case? I got another ticket from him on.
He just pled to one with Coleman Heston, I believe, today.
Yes.
It's another paraphernalia.
All right. Were you on probation or parole on November 26th of 23, which is the time of this offense, and we're only getting around to it now, a year and a half later, because you've absconded for so long?
No,
You were not on probation or parole back then?
I've only been on probation for a year.
I'm sorry?
I've only been on probation for a year.
I can't even hear with these acoustics. I don't know how I'm gonna do this. I'm gonna have to take the courthouse down to the jail, I guess. I can't even understand these guys.
I've only been on the probation.
Wait. Back up a little bit. Just back up. Move your head back away. I find the acoustics are, instead of a negative 13, they're only a 1.5, but stay back where you are. Were you on probation or parole on November 26 of 23?
No.
Are you sure?
I only been on probation for Wyandotte.
I didn't ask you that. I'm just asking, are you sure you weren't on probation or parole in November of 23?
I'm sure I wasn't.
All right. Anybody force you to plead guilty?
No.
Your mother's been sitting in here for 3.5 hours or thereabouts. I'm ordering a screening and assessment. And the bad thing is,
My mother's there?
your mother's here.
My mom's there?
Wait a second. Is that not who you said you are? Yes, that's your mother. She's sitting in the second row. She's been sitting. Pardon?
No.
No, he can't see you.
I can see it.
It looks like I took this plea back in December of 23, though, in order to screening and assessment. I don't know why. Yeah, he didn't appear for sentencing, so I just took another plea for nothing, but that's fine. Lisa, counsel, I don't need to take this plea again. This plea was taken back in December of 23, December 20. Make sure JIS reflects that, Lisa. But see, when they don't show up, these are the kinds of things that happen. I'm going to order a screening and assessment. You're fooling around with methamphetamines. Not good. Not good. You're still fooling around with meth. Was the other one meth?
It was a paraphernalia.
I know, but what was the?
I didn't get.
What was the paraphernalia in front of Judge Heston that you had? I'm going to find out. Don't lie to me.
It was for marijuana.
Nah.
Your Honor, if I may.
Yeah.
It was Caitlin Foley Carter in Beaver Brownstown Township. It was possession of methamphetamine.
This one that just happened in front of Judge Heston.
Correct, and he pled guilty.
The ads in Vegas were 2001 that he was lying to me. I don't know what you think I am. If I look dumb, you can tell me I'm dumb.
I'm not lying.
Well, you're not telling the truth. They're not going to stop you for having marijuana. Marijuana is legal now. What do you think?
I'm already doing a screening right now.
Stop. Just stop. I feel sorry for your mom, not you. You've been avoiding us for a year, 15 months, 326. I'm continuing the bond. We're going to have another screening done, Lisa. I don't know. They were saying they had to take them to medical. I don't know how they can do that. If probation can hop on now, maybe you can talk to them. You got warrants all over the place. 1, 2, 3, 4, 5, 6. You can't do this.
How do I have 6 warrants?
I don't know. Because you didn't show up in 6 different courts. I have no clue. I don't keep track of that. I'm not the one who put these on the liens. Sentencing date, let's make it quick, Lisa, when Mr. Baldwin's here next, and I will be more courteous with him than he has been with us.
April 9th at 8:30.
April 9th at 8:30. Is that the earliest we can do it?
Yeah, that's the next time he's here for a docket.
April 9th at 8:30. Let's get them in here to do screening probation.
Probation does it through the jail. He doesn't have to wait.
Okay, good enough. Thank you. Thanks for, I'll learn something today. All right, I'm going to, unless there's something else ready right now, we're taking lunch.
Jessica Jarrett. And
That's what we're going to address in just a second. Judge.
oh,
Hold her
okay,
phone.
the lady that failed to appear. Okay,
Yes, Your Honor. And
You're
once we get
late.
everybody else on, we could address that if the court will allow us to.
we will. We will now be back on the record in GW 2024 CR 176. State of Kansas versus Jessica Ann Garrett. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
The defendant, Ms. Jarrett, appears in person via Zoom with counsel Christopher Ambrose of Harvest Legal. Judge, I asked if we could call this up. This morning, Ms. Jarrett was scheduled for a 10 a.m., if I remember correctly, preliminary hearing. She failed to appear at that point. My office was contacted, I think, between the 11 o'clock and noon hours from Ms. Jarrett. She had indicated that she had a probation appointment that she was trying to get to. I believe it was probably with the Wilson County folks. And she had been having car problems, and because of that, she'd lost track of time as she was trying to get over for the Wilson County thing. I had told her that since she had contacted me right away and I had afternoon court with you, I would ask the court to get this placed back on this afternoon if we could to address this. So kind of where we're at is it was Miss Jarrett's desire to have an evidentiary preliminary hearing. Now that's kind of messed up for the day, and I understand that. But my request is that we could at least address kind of next steps and what you're going to want her to do. My request would be that the bench warrant be lifted and we get another date set for her as quick as we can. And I understand this is a little abnormal. However, she did make contact with me, so I wanted to get her on as quick as we could. And I had you this afternoon already.
All right, Ms. Jarrett, you were supposed to be here at 10 o'clock this morning. I had reserved at least an hour for your evidentiary prelim that you told me you wanted.
Yes, ma'am, I understand.
You showed up somewhere around 2:45 p.m. I have issued a bench warrant, and I'm going to order that you turn yourself in on that warrant to the sheriff. This isn't just one that I can just set aside because I've lost all this court time now. And I understand you still want an evidentiary hearing, correct?
I mean, I might be willing to waive it if I would be able to not have to turn myself in. If that would fix the problem. I understand I messed up, that's on me. So if there's anything I could do, you know, to not have to turn myself in, I'm willing to do that. It was my mistake, and I did mess up, and it wasn't my intentions. I understand you went out of your way, and I'm so sorry. Timing, I just got distracted, and I'm so sorry. I would like to do whatever I can to try to make it right. If that's waiving a prelim, I will.
I can't base the waiver of prelim on any
Right.
kind of removal from a warrant. They have to be treated as two separate things.
Okay.
There's no way that could ever be legal for me.
Okay.
Well, and that's what I was going to get to, Ms. Gillette. That's exactly right. I have to, when I take a waiver, I have to find that you're doing it freely and voluntarily without threat or promise. And I don't see how well I could take that if you're saying, well, I'm going to turn myself in if you promise to waive the warrant. I'm like Ms. Gillette.
Oh, I didn't mean it like that. I'm sorry.
That wouldn't be appropriate. Where are you right now?
I am in Neosho County.
Neosho County, are you at home?
Well, I'm temporarily staying where I'm at right now, yes. But I live in Wilson County.
Okay,
And my
so you're temporarily staying in Neosho County?
Yes.
Who are you staying with?
Tom Taylor.
Tom Taylor.
Yes.
Is that the Tom Taylor is he from Severy, Miss Gillette?
He's my landlord, but he's also a bondsman in like Neosho County, Allen County.
Okay, maybe that's where I'm hearing the names from.
Yeah.
So you're staying with your bondsman, or you're renting out your bondsman?
Well, I rent from him, but I'm having problems with my water line. So there's on his property, he has a camper. Right now, that's where I'm temporarily at until he fixes the pipes, my water line at my house. So my probation officer is aware, and I know it sounds like a mess, but with the winter, my water pipes are bad. And so I needed somewhere to stay, and I didn't have the money to pay for a hotel room until it was fixed. And so he allowed me to stay in the camper. It's on his property, but he's
All
not
right, so
there.
your landlord is your bondsman?
He's bonded me out maybe a year ago is the most recent time, but he's not currently my bondsman, no.
Okay, but your previous bondsman is your landlord. Who's your bondsman now?
Jerry Collins bonded me out of Greenwood County.
Did you make it to your probation meeting in the other county today?
I made contact because I was going to be late, and she let me go. She said I could come in on Monday morning at 8 a.m.
So the answer to my question is no, you didn't make it to court or to your probation appointment,
Correct.
but your probation officer allowed you to change your appointment.
Yes. I don't ever miss courts, and I'm really trying to do better.
I'm going to order that you turn yourself in to the local sheriff. Miss Gillette, have we got that warrant out yet? Paperwork?
Judge, my office has processed the paperwork. It is probably in your queue.
Okay. You need to turn yourself in on that warrant. You didn't make it to court because you had a probation appointment, but you didn't make it to probation. So I'm not going to set aside the warrant. Usually I will, but not under these circumstances. And your attorney was trying to find you and you couldn't be found. So, all right. If I find out you don't turn yourself in, you're going to probably get a higher bond. All right.
I'll be there.
Do we need to reset this maybe? Or just wait till she gets picked up? Let's do that. We'll wait until you get turned in and then we'll give you a new court date. All right, if there's nothing further, we'll be in recess for these hearings today.
Thank you, Judge.
Thank you.